My lords, if I may make mention.
Yes.
My lords, this is an unlisted item, my lords. If the same may be listed, one writ petition 39 of 24. Unlisted, my lords.
What is the
My lords,
urgency in the matter?
we're seeking withdrawal, my lords. Some new facts have arisen.
Okay, withdrawal of
Yes,
the writ
ma'am.
petition. Fine. Sister.
May it please your lordship, in respect of item number 4 of part 2, my lord. Item number 4, RSA number 6 of 2019.
Yes.
Thursday, my lord, if your lordship can accommodate.
Okay,
me
Thursday.
I have taken the consent of the lord.
Noted.
May I seek your lordship indulgence in mentioning item number 7 of hearing list?
7.
Yes, yes.
Yes.
Ma'am, lordship, my senior is out of station, so we need more time for the hearing.
You're afraid for adjournment. Who's your
Yes,
senior?
my senior is Joseph L. Rentley.
Okay. Yes, you're for the appellate?
Yes, my lord. On behalf of my senior, Mr. Bilaramenga. And meanwhile, my lord, if paper book may be prepared.
In an RSA, it's not required.
I do not know, my
It's an
lord.
RSA.
That is how my senior instructed me to do so.
We'll see. Let him be present. This has been listed for hearing already, isn't it? And in an RSA, it's only the substantial questions of law that has to be looked into.
Yes, my lord.
Under such circumstances, I don't think a paper book is required.
Okay.
Anyway, the learned counsels for both the parties are duly represented by their juniors. And in view of the above, as prayed for, the matter is adjourned for
May,
when do
2 weeks.
2 weeks? For 2 weeks, yes.
Promotion, part 1, item number 1.
Yes, my lord, by this writ petition, I am challenging the order dated 6/8/2024, by which the engagement order of the petitioner as security guard at One Stop Center, OSC at Khozol, under Mission Shakti Women and Child Development on contractual basis, co-terminus with the scheme was cancelled. And also the impugned order dated 6/8/2024, by which the respondent number 6 was engaged as security guard at One Stop Center at Khozol.
Let's see the engagement order.
The engagement order is
You're saying that he was engaged and
Yes.
it was later cancelled.
yes, 30, page number 19, my lord, 31/7/2024.
Yes, read the
Yes.
terms of, yes. Read the engagement order.
Yes, this is the engagement order.
Read it, please.
On the recommendation of the Departmental Screening Committee, DSC held on 25th July 2024 and 26th July 2024, Emmanuel Ruadli and sons of H.C. Lalkuma, Khozol Bengthar is hereby engaged as security guard at OSC, Khozol under Mission Shakti, Women and Child Development on contractual basis, co-terminus with the scheme at a fixed monthly remuneration of rupees 11,400 only with effect from the date of joining and until further orders. Joining report is to be submitted within 10 days to the CDPO Khozol, failing which the appointment shall be treated as declined.
Yes, so that he gave his joining report.
Yes, I have given joining report
Where is it?
in page number 23. Then the English translation is at 24.
Okay. So he gave his joining report on 9th August.
Yes, but his engagement report was cancelled by order dated 6/8/2024.
That is at page
22.
22.
And 21. 21 is cancellation order.
Okay, it has been cancelled.
Yes. It has been cancelled on 6/8/24.
Oh,
Then I have submitted my joining report on 9/8/24. That is because I am not informed that my engagement order was cancelled.
so after the cancellation
Yes,
of your joining report, no, after the cancellation of your appointment, you
Yes.
filed a joining report.
yes, I filed a
Isn't
joining report
Now, the
because,
condition is that within 10 days,
yes,
this is 31st July. So
Yes.
was it within 10 days?
in
Yes,
9 August. joining
9th
report is
August, so it is within 10 days.
But my appointment, my engagement
Okay,
order was
we'll have
cancelled
to
on.
see as to why it was cancelled. Yes,
Yes.
we can issue notice. Heard Mr. Lalpian Fela Tsongto, learned counsel for the petitioner, who has filed the instant writ petition challenging the order dated 6th August 2024, whereby his appointment letter, wide office order dated 31 July 2024, wherein he was engaged as security guard at OSC, Khozol under Mission Shakti, Women and Child Development on contractual basis, within brackets, co-terminus with the scheme, close bracket, at a fixed monthly remuneration of rupees 11,400 with effect from the date of joining till further orders, was cancelled by the said impugned order dated 6 August 2024. Without issuance of any show cause notice or any prior information, because of which the petitioner had submitted his joining report on 9th August 2024. Issue notice of motion to the respondents. Ms. Caroline K. Lalungoitu, learned government advocate, accepts notice on behalf of the
Respondent number 1 to 5, my lord.
state respondents number 1 to 5. No need to issue a formal notice. Requisite copy of the writ petition to be duly furnished to the learned government advocate. Meanwhile, notice be issued to respondent number 6 through registered post with AD, returnable by 3 weeks. List after 3 weeks.
Obliged, my lord.
Admission, item 2.
My lord,
Yes.
can we have this after part 1 matters? After finishing part 1 matters.
Okay, you want it to be a time being matter. Respondents?
I'm for respondent number 5 and 6.
Oh. What is the matter about?
My lord, it's regarding the applicability of 2013 Land Acquisition Act, while the petitioners were awarded under the 2016 Act of Mizoram Land Revenue Act, Land Acquisition Act.
So this
I have
matter has
brought
been
I have brought the judgment of the division bench.
Okay. Which is not in the file. So you want it to be a time being matter, is it?
After part 1, my lord.
Okay. But this matter has been listed under part 1 as
Yes, my
it
lord.
is.
I mean to say that after
You say
finishing
you
the
want
part
it to be a time being matter,
Yes,
so
my
we'll
lord.
make it
Yes,
a
my lord.
time being, isn't it? Yes.
Item 3.
Yes.
May I please proceed? My lord, as per order dated 30/9/2024, I have taken steps upon service upon respondent number 11, the newly implemented party.
Yes. So
And
return of
service
service
upon
of
respondent
notice.
number 11 is complete, it seems, my lord, from the records.
Notice was issued,
Issued and
then
I believe the service upon respondent number 11 is complete.
let's see the correspondence file.
I have got the information that the service upon respondent number 11 is complete.
Postal receipt received from postal office on behalf of, yes. Duly signed? Let's see.
DCI is all, my lord.
So the seal of the Office of Deputy Commissioner is here in the acknowledgement, isn't it? Anyone representing responding number 11? Yes, heard Mr. L.H. Lianchima, learned senior counsel for the petitioner. The learned senior counsel submits that notice is received by the newly implemented respondent number 11. This court on perusal of finds that on perusal of the correspondence filed finds that an acknowledgement letter it finds that the acknowledgement card is returned with the seal of the deputy commissioner. Is it Aizol? Yes, Aizol, duly affixed on the acknowledgement card. In view of the above, notice is deemed to be complete upon respondent number 11. None appeared for respondent number 11. In view of the above, this court find it fit to fix another date for the respondent number 11 to be duly represented. Yes. Anything else? List after 2 weeks.
2 weeks. Obliged.
Item 4 to 8.
My lord, in item number 4, as per office notes, there is no return of ID card from the respondent number 11.
Okay,
So if the same may be awaited.
heard Mr. T. Zakima, learned counsel for the petitioner, who submits that as per the office note, it appears that return of AD card from respondent number
11.
11 is still awaited. In view of the above, list this matter after 2 weeks. Who is respondent number 11? The DC? Okay, after, then let's make it 3 weeks if it's Seha.
My lord.
Isn't it? List after
My lord.
3 weeks. Yes, Ms. Iram Sangpui, anything to submit in this matter?
My lord, I already filed my so-called reply.
Yes, it is seen that respondent number 9, represented by Ms. Iram Sangpui, learned counsel, have already filed their show cause reply. In view of the above, list after 3 weeks.
Obliged.
Obliged.
Item 9.
My lord, the connected writ appeal number 90 of 2024 was listed on 5/11/2024. Then the matter will be listed again after 2 weeks from the day. Then, my lord, the matter may be listed again after 3 weeks, my lord. If I may permit it to produce.
Okay, heard Ms. Hazaram Sangpui, learned CGC, for the respondents, who submits that the connected writ appeal is still pending before the principal seat. And in the order dated 05/11/2024, in the connected appeal, the matter has been adjourned for 2 weeks. We thus prayed that the instant writ petition may be listed after, let's make it 4 weeks,
Yes, my lord.
awaiting further disposal of the connected writ appeal.
Obliged.
In view of the above, list after 4 weeks.
Item 10.
My lord, as per the direction of this honorable court, we have taken steps upon the respondent number 1 on 24/9.
Yes, but now, in the office note dated 15/10,
My lord,
the notice upon respondent number 1 was returned with a note that not found returned to the sender. Then, after that, what steps have you taken?
after that, my lord, this is the first instance it has come. So, my lord, if I may be allowed to take steps for newspaper publication.
Who is respondent number 1?
My lord, respondent number 1, he was the president of HT Enterprise Private Limited.
So his address is given here,
Yes, address is given.
opposite CT Hyundai Bongkon, Lunglei Road.
Yes,
So now this is returned with the note that this address is not found, is it?
yes, my lord.
See, because
And-
the address itself is very vague. No house number, nothing. The address you have given is simply opposite to CT Hyundai. So take necessary steps to find out.
My lord, my lord.
Have you taken any steps? I'm
We
just
have
wondering.
taken steps.
How?
However, my lord, and also fresh step was taken upon to the
Respondent now.
to the correct address that we have
So
been
what is the
informed.
correct address?
However, my lord, it seems that there is they have no longer resided in the place. So if I may be allowed to make newspaper publication.
You see, this person, his name is a Mizo person,
Yes.
isn't it? H.
Yes.
Moya. And then he is a president of an enterprise known as HT Enterprise Private Limited. Let's see where is the correspondence file showing what steps you have you taken. Because here the office note shows that, wait, let me see. Shows that with reference to this court's order dated 4/10/2024, steps not taken by the learned counsel for the appellant till date. So though you have said that steps have been taken,
My lord,
the office note says that steps were not taken by you.
my lord.
You see, that's what. The office note dated 8/11/2024 says, in terms of this court's order dated 4/10/2024, fresh steps have not been taken by the learned counsel for the appellant.
My lord. My lord, in that
Then
case,
you'll have to show how you have
Yes.
taken fresh steps. Have you taken or not? I don't
lord-
think you
my
have
lord, in that-
taken. You have to take fresh steps through the registry.
in that case, if I may be given
Yes,
a week's
for the
time, my lord.
time. Take fresh steps, show that you have actually taken steps, and in spite of that,
Yes.
you cannot serve notice. Then we will consider whether newspaper publication is required or not,
My
isn't
lord,
it?
my lord.
Heard Mr. T. Lalzakima, learned counsel for the appellant, who has prayed for further time to take fresh steps upon respondents number 1 and 2.
1 and 2.
Okay, 1 and 2. Accordingly, as prayed for, list the matter after. When do you want it? 3 weeks?
My lord,
3 weeks.
deeply obliged.
Item 11.
Yes.
My lord, since this petition has been in the filed in the form of a writ petition,
Oh,
though it's a petition under Article 227, and they are challenging the dismissal of the review petitions. I think the remedy under Section 115 of CPC is also available to the petitioners. So in that terms, if I may be granted a 2 weeks' time to file affidavit in opposition.
you are representing respondent number?
1.
Here, in the last court date, there was this person, Lalrinzwala Colney.
Yes, my junior. My lord.
He has prayed for time to file his part.
Yes.
Yes, Mr. F. Lale Indiana, learned counsel for the petitioner is present, along with Mr. So-and-so, learned counsel for respondent number
1.
1. The learned counsel for respondent number 1 has paid for further time to file the counter affidavit. Yes, then Miss Caroline Kayla Longpui, learned government advocate, has also paid for time.
3, my lord.
Pardon?
Responding number 2 and 3.
For respondent number 2 and 3, has also prayed for further time.
No, my lord, we will not be filing our affidavit in opposition.
Learned counsel, government advocate, for respondent number 2
2 and 3, my lord.
and 3 submits that they will not be filing their counter affidavit since they are only pro forma, is it?
No, my lord, but
Why not filing? Why aren't you filing
I
here?
have received instructions from the department and they are saying that we have nothing to comment. And since this is a private dispute, we will not be filing our
So you're simply pro forma, isn't it? Who submits that she has received instructions that they will not be filing their counter affidavit in the matter. In view of the above, the list after 3 weeks for the learned counsel for respondent number 1 to file their counter affidavit. Yes.
Obliged, my lord.
Item 12.
I seek your lordship's indulgence. My lord, I am appearing on behalf of the respondent number 7 and 8, and I have not yet received the parawise comments.
My lord, I am for respondent number 1 to 6.
I seek another 3 weeks' time for filing my affidavit in operation.
Yes. Ms. Caroline K. Lalungopui, learned government advocate for respondents number
7 and 8, my
7
lord.
and 8, along with Ms. Zarin Sangpui, learned counsel for respondent number 1 to 6, have prayed for further time to file their counter affidavit. Yes, the petitioner is duly represented by Mr.
Simon Thang Asylum.
Signing Asylum, learned counsel. In view of the above, list after 3 weeks.
Right. Item 13.
Lordship, I'm appearing for the respondent, Mizoram Rural Bank. Lordship, we have received instruction from the bank. However, we haven't fully prepared our affidavit, so may we be granted 2 weeks' time for filing our affidavit?
Mention is made on behalf of
Mr.
Mr.
Sizoram
Sizoram Chana, learned counsel for the respondents for further time to file their counter affidavit. Mr. T. Zakima, learned, you're the legal aid
Legal aid
counsel?
counsel, madam.
Learned legal aid counsel is present and has not raised any objection. In view of the above, list after 3 weeks.
3 weeks' time.
Item 14.
Lordship, in this matter, this respondents number 1, 2, 9, 5 to 8, they have already submitted their affidavit. And respondents number 3 and 4, they did not submit till date, Lordship. And with regards to respondent number 4, it seems
Who
that
is representing 3 and 4?
3 is Kala and 4 is the Ministry of Road Transport and Highways, Government of India, Lordship. And with regards to this Ministry of Road Transport, we will take a fresh steps if your Lordship allow us.
The respondent number?
4, Lordship.
4.
We'll take a fresh steps, yes. Lordship.
Okay. Then what about 3?
3,
Notice
Lordship,
is complete?
Notice is deemed to be complete, Lordship,
Let's
if I'm
see.
not wrong.
The state respondents are respondents number what? 1, 2?
1, 2, and 9.
1, 2, and 9. So who's respondent number 3?
3 is Kala, Lordship.
Not represented? Is
Not
notice
represented
complete?
as of today, Lordship. This is Deputy Commissioner.
Okay. The office note dated 15/7 says that AD card returned from respondents number 3, 6, and 7. Okay. So 6 and 7 is, okay, you're a
It is NHIDCL and we have already filed, my lord.
You have already filed, okay. So, heard Mr. Johnny L. Tocho, learned counsel for the petitioner, who submits that he may be allowed to take fresh steps upon respondent number 4.
4, Lordship, yes. During the course of the day, Lordship, this CGC is available, then we will serve a notice.
Let's see whether she'll accept or not. Isn't it? First,
Yes.
Praise it out. List after 2 weeks.
2 weeks, Lordship, yes.
Yes. It is seen that, wait, let's make it, it is seen that respondents number 1, 2,
And 9.
1 and 9 are duly represented by the learned government advocate, while Mr. Samuel L. Changte, representing respondents number
5 to 8, ma'am.
5 to 8 is present. It is also seen that none appeared for respondent number 3, though the office note dated 15/07/2024 indicates that AD card is returned from respondent number 3. Yes, in view of the above, list after 2 weeks.
That's all right, Lordship.
Item 15.
May please, Your Lordship, in this matter, may I kindly be given 1 more week to file my
what? File your
affidavit?
counter?
Yes, Your Lordship.
Let's see.
We are preparing it and we'll be finalizing within 1 week.
Okay. Mr. Attila Zekimal, learned counsel for the petitioner, is present along with Mr. Lalchandiana Kiante, learned counsel for respondent number 123. The learned counsel for the respondents have prayed for further time to file their counter affidavit by submitting that they are in the stage of preparing the counter affidavit. In view of the above, list after
1 week.
1 week.
Be obliged.
Item 2.
Yes, time being matter. So you're saying that there's a judgment of the division bench
Yes, my lord.
which settles the instant writ petition, is it? So where's the copy of the? Okay, so what does the judgment
There are
say?
two writ appeal number 70 and 71 of 2018. This was by this common judgment 30/10/2024, and if your lordship may kindly see para 10. The decision held by the learned single judge. The learned single judge, after hearing the learned counsel appearing before the parties and after taking into consideration the rival stance of the parties, has disposed of the writ petitions in the manner indicated above, by the impugned judgment law that is such and such. The learned single judge has recorded the finding to the effect that the Mizoram Land Acquisition Act is not applicable in the state of Mizoram, and the private respondents with petitioners are liable for compensation as per the provisions of the Act of 2013. Being aggrieved, they have preferred this appeal, and coming to, if I may take a lordship to para 37 onwards.
Yes.
There is no justification in the action of the state government of denying the relief to the private respondents with petitioners of determining the compensation in lieu of acquisition of their lands by applying the provisions of the Act of 2013, when the same benefit has been given to the other set of citizens of the state of Mizoram. The action of the state government is clearly discriminatory and violative of Article 14 of the Constitution of India, and the same cannot be approved. It is true that Section 107 of the Act of 2013 provides that nothing in the Act of 2013 shall prevent any state from enacting any law to enhance or add the entitlements enumerated under the State Act, which confers higher compensation than payable under the Act of 2013, or to make provisions for the rehabilitation and resettlement, which is more beneficial than the provision under the Act of 2013. However, since the findings of the learned single judge that the Mizoram Land Acquisition Act is less beneficial to the citizens of the state of Mizoram, and therefore is not in conformity with the provisions of Section 107, has already been affirmed by us, the same cannot be interfered with. Resultantly, no case for interference with the impugned judgment order 15/11/2017 passed by the learned single judge in WPC number such and such is made out. Therefore, both the writ appeals revert on behalf of the state of Mizoram are dismissed. So, my lord, coming to the present case, the petitioners, the land of the petitioners were situated within Siha district, and they were given the award number 10 of 2023 under the Act of 2016. If I may take a lordship to the said award, page number 65. Page number 66, annexes.
Wait, are we on the same page? Page number 65. Yes.
Page number 66, my lord. This award number 10 of 2023, location, Tipa, Lucky Lope, Lopu Road. Purpose of construction, acquisition. Construction of road from such and such 50 to 70 kilometers in Siha district. And on the para 1, my lord, under the introduction, whereas the land is required by the government for public purpose for construction of such and such road within Siha district, Mizoram, and that for the said purpose, the Secretary to Government of Mizoram Land Revenue and Settlement Department has issued preliminary notification under Section 11(1) of the Mizoram Act 2016, by memo such and such, and wherein the government appoints a deputy commissioner of such and such. So it has been initiated under the Act of 2016, this award.
Yes.
And if I may take a lordship back to page number 62. Page number 62, Annex 3.
Wait, initiated, just come to back to this point. It was initiated under the 2016.
16, Mizoram Act.
When was this?
This
In
award was
which-
made on 25th January 2023.
Okay, 2023.
And if I may take a lordship to page number 62, the notification, preliminary notification issued under section 11. Page number 62, NSA 3. Preliminary notification dated 16 October 2019. Here, my lord, I would like to draw your lordship attention to para 8 of this notification, which is at page number 63.
Yes.
This notification was issued under the Act of 2016, Mizoram Act, and this para 8, it states that this notification will not stand in the way of the petitioners or cause any prejudice to them to make a further claim under the Act of 2013, depending upon the outcome of the writ appeal number 70 of 2018, appealed by the government of Mizoram in the Division Bench of Guwahati High Court, Guwahati. So, after finalizing this award number 10 of 2023, my lord, they have already disbursed the compensation amount to the petitioner's hearing under the Act of 2016.
2016,
And
okay.
the present writ petition has been filed, my lord. If I may take a lordship to the prayer portion of my writ petition, page number 34.
Yes.
A, the impugned award 10 of 2023 should not be interfered, modified by directing the respondents to pay compensation to the petitioners under the Act of 2013 with all the consequential benefits. Second, the respondents numbers 5 and 6 MIDC should not be directed to release the deducted 10% cess to the petitioners immediately. C, the respondent number 4, DCCR, should not be directed to make assessment of interest in terms of Section 80 of the 2013 Act, and thereby to direct the respondents PRTF to ascension the assessed amount and make payment to the petitioners immediately. D, the market value of the lands of the petitioners should not be enhanced in proportionate with the rate admissible to other parts of the state, and thereby direct the respondents to make payment in terms of the enhanced amount. My lord, so far as the prayer of the under D is concerned, I will not press this because now, as of now, the Act of 2016 is not is inapplicable, and after making the award under the Act of 2013, this will came into play after only making the fresh award under the Act of 2013. And so far as prayer number C, my prayer C is concerned, my lord, this is in respect of payment of interest. In as much as the notification which I showed you earlier, my lord, under Annex 3, was issued on 16/10/2019. But prior to that, my lord, the state respondents had issued another notification on 17 May 2017, which is at page number 39. Page number 39. Annexure 1. Page number 39. Prelim notification dated 17 May 2017, my lord. Here, my lord, if your lordship may kindly see para 6, second last paragraph from the bottom. In terms of this notification, my lord, they have taken the position. No new allotment of land or change of nature of land rights shall be made within the affected area by the authorities concerned after the date of publication of this notification. And in the impugnable, my lord, the respondent authorities has taken the date of Annexure 3, page number 62, which was subsequently issued in the same nature. 16/10/2019. They have taken the date, this date, for calculation of the interest. While the date of this first notification issued on 17/5/2017 should be taken into account.
Okay, so it was taken at 16:10. Well, it should be 17/5.
Yes, my lord. Yes, my
Is
lord.
it?
Yes, my lord.
Hmm.
And with regards to my prayer B, regarding deduction of cess, my lord, this impugn award 10 of 2023 has been made under the Act of 2016, which the Honorable Division Bench now held that it is not applicable within the state of Mizoram. So all the action, all the things done under the Act of 2016 are now null and void, without prejudice to making further assessments in terms of the Act of 2013. So this 10% deduction of cess is also illegal. And the
Where's the 10% deduction?
if I may take your lordship to page number 69, which is the award 10 of 2023. Page number 69, my lord. Para 3, column number 3. Says at the rate of 10% of the total cost of land will be deducted from the individual owner and shall be remitted to MIDC directly. And as can be seen from the affidavit filed by the state respondents, my lord, this deducted 10% cess is still lying in the office of the DCCH without remitting it to the account of the MIDC.
Yes.
Your lordship may kindly see the affidavit in opposition filed by the state respondents number 3 to 5. Para 10.
Yes.
That with regard to statements made in para 12.1 of the writ petition, I say that it is a fact that 10% cess have been deducted from the petitioner's land value by invoking section such and such of the MIDC Land Revenue Act 2018. However, the cess deducted is not yet released to the Revenue Department, MIDC, and is kept pending with the district collector in compliance with instruction from the state government via letters such and such. If the Honorable High Court dispose the matter in favor of the petitioners, the respondents are willing to comply with the court's order. They are referring to letter dated 20/12/2021, whereby they have received instruction in this regard. The said letter is in page number 37 of the affidavit which I'm referring, page number 37. This is addressing to all the deputy commissioners, district collectors, Aizol, Lunglei, Siha. Subject says deducted in respect of temporary pass regarding. Sir, Madam, with reference to the subject cited above, I am delighted to state that the Guwahati High Court issued a couple of impugn orders wherein the government of Mizoram is directed to release the amount of cess deducted in respect of past with regard to railway line project in the state, and the impugned orders are being challenged in the principal bench, Guwahati High Court. Consequently, the court disposed of the same case in respect of WPC number such and such. And again, the state
So,
government.
what happened to this? The appeal 105, is it the instant?
No, my lord. This is in different case, but they have issued this instruction to withhold all the deducted cess in the office of the DC.
Yes.
So, in the present case, my lord, the deduction and all the proceeding was done under the Act of 2016, which was now held inapplicable. By
So, under the
division bench.
2013, there is no provision for deduction for cess, is it?
Yes, my lord, there's no provision. Moreover, my lord, there are a series of judgments rendered by this court that when the acquisition was done under the Central Act, this cess cannot be
Yes,
deducted.
cess cannot be, huh? So,
In spite of that, my lord, in the present case, since the Act of 2016, which was applied to the case of the petitioners, was held inapplicable, so the deduction of cess is illegal, and they are liable to be directed to refund the same to the petitioners immediately.
yes, anything to say, the respondents in this matter? State respondent is duly represented? Yes, Ms. Malsawari.
Yes, Lordship, I'm appearing for the state respondents. Lordship, it can be disposed of as per the
No
principal
steps
bench
taken
order.
by the
Yes.
state respondents to appeal to the higher authority? Any
Lordship,
steps?
at this stage, we have no instruction with regards to
Okay.
that, so.
Oh. You see, because I'm just asking that question, because if steps are taken and the state respondents are taking steps to file an appeal against the instant dispose of writ appeal, then we'll have to see.
Lordship,
Or-
if I may
or-
be given some time,
or is it
at the,
yes, or is it who is to pay the compensation? Is it the CGC or the state
yes,
CGC?
it's the
Yes, CGC.
central government.
CGC, anything to say in this matter?
My lord, I have nothing to say because regarding the applicability of 2016 and 2013, I can accept any order passed by this court, my lord.
Okay, no steps have been taken to appeal against, I'm just wondering, okay, if any steps are taken, then we can wait for some time, if not, as will allow, huh?
My lord,
Yes.
so far as the respondent number 5 and 6 MADC is concerned, my lord, they are raising the issue of the 10% cess, my lord. This 10% cess is, my lord, deducted in accordance with the Mara Autonomous District Revenue Act, my lord,
Okay,
section 23(2), my lord.
Oh.
That provides for, that allows the MADC to deduct certain amount of cess, my
Okay,
lord.
10%
It is not that,
cess.
my lord.
okay, so it's not under the Central Act or anything, it is because under the
My lord.
Mara Revenue Act, huh?
My
What do you
lord.
have to say in that matter?
My lord, in this regard, keeping in mind the fact that whatever they have done under the Act of 2016 are illegal.
But is it under the 2016 Act? This 10% cess which can be taken by the district council.
My lord,
We'll have to look at that.
Yes, ma'am.
Where's the act?
my lord, if your lordship may kindly see page 68 of the award, my lord, read petition, my lord.
Page 16 of the writ
68.
petition. 68.
68, my lord. Next is 6. This is award number 10 of 20.
10% cess
My lord,
in the award.
my lord. As provided by subsection 2 of section 23 of the Mara Autonomous District Council Land and Revenue Act 2018, 10% of land value shall be remitted to Land Revenue and Settlement Department (ABDCSIA) assessed on the value of land with effect from 10/99/2019. Void notification memo dated 23/9/2019, my lord.
Yes, so what about this?
My lord,
Now, we'll have to look at this Mara Autonomous District
Yes, my
Council
lord.
Land Revenue Act.
page number 92, my lord, page number
Yes,
92 is there.
92.
Yes, my
I
lord.
can close.
It starts,
The
How did this
respondent under the MADC are
originate? Yeah, let's
wholly
see the first.
misconceived in applying this provision, my lord. If I may take a lordship to page number 92,
Yes.
section 23.
Huh.
Before that, Page number 86, my lord, the starting of the said notification.
Yes,
Page number 86.
how did this notification originate, from where, what?
Page number 86, my lord. This is the Mara Autonomous District Council, Land and Revenue Act 2018. And under this, my lord, section 22 and 23, my lord, it's regarding land survey and spot verification, which is in page number 92. I'll read from section 22, my lord, 22.1. No land survey, spot verification and measurement over any land allotted to any person by the district council in accordance with the MADC Act and so, or any other law enforced in the district council area shall be carried on by any person, government or non-government department or agency for any purpose except by the district council. In any case, land is necessary for any purpose to be surveyed, verified or measured. The owner of the land in question shall apply for the same in writing before the concerned authority under the district council, and the concerned authority shall perform such required work as and when it deems necessary and in the manner as it may deem appropriate. In certain cases, the concerned authority may, on its own initiative, perform such needful work under this section as it may find necessary in presence or consultation with the landowner or otherwise. Section 23.1. The executive committee or concerned authority in its behalf may, by public notification or by official order, levy or collect, fix or control revenue, cess, post, and charge payable by any landowner or pass holder, and may prescribe the manner and period in which such revenue, cess, post, ban charges are to be paid and collected. In exercise of the power vested to it by subsection 1 of this section and subsection to the provision of section 22 of this act, the executive committee or concerned authorities shall be competent by public notification or by official order to collect revenue from any land pass holder as it may deem fit and reasonable, to collect and levy cess to the extent of 15% of cost or charge, which may be increased or decreased and fixed by the executive committee from time to time, by official order notification from any landholder, from the value of the land, and on any other ground in the manner as may be prescribed from time to time for the conduct of spot verification, survey, and measurement, or any other administrative work or administrative or otherwise as provided and invited under such and such. You also may kindly notice that the act which they have made by the council, district council, it provides the provision for deduction of payment of administrative costs or cess, as whatever they may call it. But it does not specify or mention that it can be done under the land acquisition proceeding. So the respondent authorities under the MIDC are wholly misconceived in applying this provision for deducting 10% cess from the land acquisition proceeding, from the land value, from the amount of the petitioners, my lord. Under the state, those judgment which was already rendered by this court, including LOC, my lord, regarding illegal
Give me
deduction
a
of...
copy of those judgments and facts. Let me see. Because if I'm not mistaken, those will be the DCIs most probably.
And
Anyone, anything for the district councils?
no, my lord. In those cases, my lord, in the Mizoram Land Revenue Act
Yes,
and the
that
rules,
is the Mizoram
they
Land
have
Revenue
stated that
Act.
cess will be deducted if the acquisition was done under the L Act of 1894 or such and such. They have
Yes.
specified
But
the
1894
provision.
has been repealed, isn't
Yes, my
it?
lord. Thereafter, they have specified which act or proceeding, land acquisition proceeding. But in the present case, my lord, the provisions nowhere provided that they can make deduction in land acquisition proceeding.
Yes, so here, if you look at 22 and 23,
Yes, my lord.
you're saying that this does not include land acquisition proceedings.
If I may take a look back to the relevant portion, page number 69, my lord. This is the part of the award, page number 69,
Yes.
column number 8. Here, my lord, this administrative cost was already deducted. This includes
Okay.
the land acquisition proceeding was, the award was prepared by the district collector of Siha, and all the proceedings, including verification, whatever has been done under the staff and employees of the district council. So it already included everything under this, my lord. And under any circumstances, my lord, as I submitted earlier, so long as the deduction of cess was done under the Act of 2016, that itself is void ab initio.
Okay. And administrative cost has already been deducted.
Yes,
That
madam.
is your point. Okay, anything else?
My lord, the petitioner also pay interest as per section 80 of the new act, my lord. However, regarding the taking possession of the land, my lord, they are trying to state it that the taking possession to be counted from 17/5/2017. That was first preliminary notification has been issued. However, my lord, the notification for the purpose of this land has been issued in the year 2019. That is Annexa 3, page 62
Page
of the
62.
writ petition, my lord.
So you're saying that it should be from 16 October 2019?
Yes, my
Is
lord,
it
instead of 2017.
instead of?
2017, that is page. Page 39, my lord. The petitioner pray for as per page number 39, my lord.
Let me
However,
just
my
come
lord,
to page number 39.
the notification was 16 October 2019, page 62.
So it should be from 2019,
Yes,
isn't
madam.
it? Instead of 2017,
Yes,
that's
my
a
lord.
submission.
Yes,
My lord, if your lordship may kindly come again to page number 62, it will be clear from here. I have not read the entire thing. If I read the entire thing, my lord, page number 62.
Wait. Yes.
Page number 62, my lord. This is dated 16 October 2019. Whereas the previous preliminary notification dated 17/5/2017 issued under subsection 11 had already lapsed for taking further possession under the Act of 2016 for possession of land by the requiring department, and that the land specified in the schedule shown below is likely to be needed for the public purpose. Here, my lord, they have, since the other notification was lapsed, they have
Yes,
again.
had lapsed. So this is
issued
the
this
second notification,
Only for
isn't it?
formality's sake. But since the time of issuance of this 2017 notification, they have already taken possession, and we cannot develop
Okay,
our-
they had taken possession in
Yes, my lord.
2017?
Yes, my lord.
The first notification.
And my lord, the first notification, if I may take the lordship again, page number 39. Page number 39, my lord. Para 6, bottom of the page, last two paragraph. After issuance of this notification, my lord, the direction is this. No new allotment or land or change of nature of land rights shall be made within the affected area by the authorities concerned after the date of publication of this notification. Persons interested in the said land are hereby warned not to obstruct or interfere with any surveyor or other persons employed for the purpose of the said acquisition. Any contract for the disposal of land so and so, otherwise, comments or improvement made therein after the date of publication without the sanction of the collector will be disregarded while assessing compensation, my lord. Since this 17/5/2017, we cannot make any further development within the land.
My lord, if I may, they just stated that no new development, no new allotment has to be issued.
The
my lord.
proviso, my lord, persons interested are hereby warned not to obstruct, interfere with, is very clear, my lord.
So you were dispossessed, your submission is that you were dispossessed
Since
in?
this notification.
Yes, 2017. Okay, while the submission of the learned CGC is that it should be when the fresh notification was issued
Yes, my lord.
in 2019.
Then no certificate for taking possession of the land has been enclosed by the petition to show that they have been taking possession of the land in the year 2017. Then in this notification that my land had read out, they just stated that they are restricted to issue new allotment only, my lord. That is my submission, my lord.
In either ways, the petitioner, they have a good case concerning applicability of 2013, isn't it? That's a settled matter, huh? Anything else to submit? I'll pass the order accordingly. And the writ petition stands disposed of.
Unlisted item with petition 39 of 2024.
So this will be the same, isn't it? 39? Item number 5, item number 4. Okay, this is an unlisted matter, but the council is not here. We'll list the matter tomorrow. Matter is called out, however, none appeared for the petitioner. In view of the above list on tomorrow's date, 12th, so